So first of all, good afternoon, everybody, or morning, depending on where you are. Probably afternoon for those of us on the East Coast. I want to welcome you all to today's webinar, Amendment to the New Jersey Family Leave Act, what all employers need to know about New Jersey leave and benefits laws before July of 2026, and it's being hosted by Saul Ewing. I am Ruth Rawls. I am a partner and chair of our labor and employment group here at Saul Ewing, and I am based out of our Princeton office. And I have two of my wonderful colleagues joining me today to also talk about this, Mark Nemi and Lisa Koblin. Lisa is a partner in our Philadelphia office, and Mark is an associate in our Newark office. Although I consider you part of Princeton too, Mark, when you pop down there. And our contact details will be at the end of the slide presentation, and you can reach out to us afterwards with any questions. So before we get into it, first housekeeping, always housekeeping first, right? So before we begin, a couple quick notes. So questions, to submit questions, please use the Q&A tool. It's down at the bottom of your screen. We will try to answer as many questions as possible today, but we'll follow up by email if time runs short. As we start getting into this, you will see there's a lot of math and counting to be done. So if we get a lot of numbers in those Q&As, it may take us a little bit to get back to you, but we'll definitely look at those and answer as much of them as we can today. Credit, also important, because if you don't get credit for it, were you really here? So let's make sure that we fill those forms out. So the program is eligible for both CLE credits in several states, as well as HRCI and SHRM credit. So to receive any form of credit, you'll have to complete the verification survey. It is linked in the resources tab, and you will enter the 5-digit codes that we've announced during today's session. There, we'll make sure that we shout them out loud and clear so that you have them. And just make sure that you submit that survey by Thursday, June 11th, to get your credit. If you have any issues with that, you can reach out to Saul Ewing and we can help you with that. Materials. We are going to go through a slide deck today. We're going to be talking. You will receive a follow-up email from our team in the coming days with both the webinar recording as well as the slides and our contact information again. And then because it's not a presentation on a legal amendment unless we give you a disclaimer. So here it comes. The provision and receipt of the information in this program is not legal advice. It does not create a lawyer-client relationship and should not be acted on without seeking professional counsel who have been informed of these specific facts. And I will say that is particularly the case here because as we go through this, you will see there are some things in this new statute that we are waiting to be interpreted and applied by the New Jersey Department of Labor to tell us what some of those things mean in a little bit more detail. So while we are covering today the status of things as they are, there may be some changes and some further guidance and clarification that comes that may alter some of the things that we're talking about. So with that, let's jump into it. So this is how we're going to go run our presentation today, just to kind of give you the roadmap for our agenda. We are going to talk a little bit about the New Jersey Family Leave Act, the New Jersey Temporary Disability Insurance, TDI, and New Jersey Family Leave Insurance, FLI. And we will do our best to get all those acronyms correct as we are talking, although there are a lot of letters involved in today's presentation. And we're going to do that because, and we're not going to get into all the nitty-gritty of all of these things, but we want to highlight the things that exist as they are now so that when Lisa starts talking about what this amendment is changing, there's some context to that. So we just want to set the table as we get into that. And then we're going to talk about what's going to happen on July 17th when this amendment goes into effect and some of the immediate changes based on the statutory language that we know are coming and some of the things that we are waiting for some guidance and clarification on in terms of where the rubber meets the road and how these things are going to play out. And then we're just going to talk briefly at the end about what those changes mean for employers, what you can do to prepare now, what you can start kind of getting yourself ready and geared up for those changes coming in July. We can go to the next slide. So let's talk about the current state of the NJFLA, TDI, and FLI. Go to the next slide, please. So the existing New Jersey Family Leave Act, which we've all had for a while, we know what it is. We've heard it, NJFLA, just basics, right? It is 12 work weeks of job protected family leave in a 24-month period. A lot of numbers coming your way, so you guys get ready. So again, that's 12 weeks in a 24-month period. That differs from what we're talking about with some of the other statutes. It's family-related leave, so it's care to bond for a child. That leave has to start within 1 year of the child's birth or placement for adoption or foster care. You're caring for a family member with a serious health condition, all things which are defined in the statute, which we're not going to get into, but generally that's what that means. And in the state of an emergency, if you need to prevent the spread of a communicable disease, and those amendments came through during the COVID pandemic. The important thing to note here as we're talking about stuff, which I think we all probably know, is that the FLA does not cover, is not applicable to a personal injury or illness. It is to care for a family member with a serious health condition. Go to the next slide. The other thing about the existing NJFLA, what does it require employers to do? It carries with it certain obligations from an employer when a person takes FLA leave. The obligation of the employer is that individual has to be restored to the position that they held immediately prior to the commencement of the leave. There is an exception, always an asterisk somewhere in a legal presentation. If there's a RIF or something while that person is out, that would be an exception to that. And if that position's been filled, then the reinstatement has to happen with respect to an equivalent position where you're not impacting the terms and conditions of their employment, meaning, similar seniority status, employment, benefits, pay, that we're not changing any of that stuff, even if it's not the exact same position they had when they went out. Go to the next slide. So let's talk about the employers that are covered as the FLA currently exists. So back in the day, it used to be 50. And it was real easy with the FMLA because it was the same number. A couple of years ago, that got changed and it dropped down to 30 plus employees. So if an employer has 30 plus employees, they're going to be covered by the FLA. Now, how do we count employees? Always the important part, right? When we count all of our employees to determine coverage. So we count inside and outside of New Jersey. We count them whether or not they're eligible for leave or not. And in certain situations, under the regs and the language, it includes subsidiaries, divisions, and other related entities that go into that count. So how we count is important when we're determining if the employer is covered. We can go to the next slide. So in addition to the employer being covered, the employee has to be eligible for NJFLA. And eligibility is they've worked for at least 12 months and they have worked at least 1,000 base hours during that preceding 12-month period. And they're eligible for leave under the statute. We can go to the next slide. So what about remote workers? Because that has come up a lot. Just wanted to touch on that briefly. So an employee is entitled to FLA right now if they meet the eligibility requirements, right? 12 months and 1,000 hours within the past year. And they physically work in New Jersey, or they routinely perform some work in New Jersey and the employee's base of operations or the place from where the work is directed is in New Jersey. So a remote worker that is performing work in the state of New Jersey is going to be someone that could potentially be eligible for NJFLA. We can go to the next slide. So that's the FLA high level and kind of previewing some of those things that have changed. TDI, temporary disability insurance, it's different than FLA. But it's different because it's not a leave in the sense that we think of it. It's really a benefit that is received from the state. And it's wage replacement benefits for the employee's own sickness or injury where they can't work. It's up to 26 weeks of state provided partial wage benefits. The eligibility requirements are on the slide. Those change depending on kind of income and things like that, sometimes in the statute and the regs, but generally this is the eligibility for 2026. And right now, under TDI, there's no guarantee of job protection. There's no right to reinstatement. Again, another asterisk because would it be a presentation without one? So right now, that is what TDI provides for you. We can go to the next slide.
Ruth, we had a quick question,
Sure.
which is, does NJFLA cover a Pennsylvania entity that has remote workers who live in and work in New Jersey, even if they are part-time? We do actually have a hypo that's a little bit on this. So do you want to save it for the hypo or do you want to?
Yeah, we can save that for the hypo because I
Okay.
think we have one that's coming up. So hold on, we're going to get there.
Okay.
Um, FLI, which is the other thing that we want to talk about just for what it exists of now before we start talking about these amendments. So again, FLI is a wage replacement benefit. It is to care for a family member with a serious health condition. It is to bond with a new child during the first 12 months of a child's birth or placement. It also applies to certain instances of domestic or sexual violence matters where someone needs leave. And again, this care for a family member during a state of emergency that deals with things that kind of came out of the COVID pandemic. But again, it's wage replacement. It's a benefit that employees are entitled to when they satisfy one of these criteria. We can go to the next slide. So what are the benefits that you can get under FLI? It is up to 12 weeks. So if we're keeping count, we've got 12 weeks within 24 months for FLA, we've got up to 26 weeks for TDI, and we got 12 weeks for FLI. And Lisa's going to tell us how all those things are going to work together after July 17th. But it's up to 12 weeks of state provided partial wage benefits. There's a difference in counting if we're talking about intermittent leave. We don't need to get into all of that, but just to be aware of it, how we count what you're entitled to is different for a leave versus intermittent leave under FLI. The employee again has to apply for those benefits. There's a time frame, 30 days within the first day of leave. Eligibility requirements look very similar to TDI. And currently, again, there's no job protection, there's no right of reinstatement or anything like that under the current system. One note I want to make just about TDI and FLI, because I don't want it to get lost, is when we're talking about the eligibility, work 20 weeks, it doesn't have to be for the same employer. If maybe an employee switched employers in that year, but has satisfied the 20 weeks and the dollar amounts, they're going to be eligible for those benefits. And that's different than FLA, where you've worked for the same employer for 12 months and for 1,000 hours in that year. So there is a difference there. And as we kind of get into the amendments, you'll see why that might make a difference in terms of the leave that someone might be entitled to. We can go to the next slide. So just a quick reference summary of all the things, not all the things, but some of the things as kind of foreshadowing of what's about to happen. Reinstatement rights, you've heard me say that a couple times. Currently, under the NJFLA, yes, you have them. TDI, no. FLI, no, with the one exception for TDI. Leave benefits. FLA is unpaid leave. There's no benefit that's provided. You're not required to get paid. You can run paid leave in the same time, but there's no requirement for that. For TDI and FLI, those are benefit programs that provide wage replacement through the state. So that is the state of play as it currently exists. So now Lisa's going to tell you how all of the things I just told you are going to change on July 17th. So Lisa, I will turn it over to you.
Thank you, Ruth. Yes, I know we're all really excited. We've circled and bolded this date in our calendar, and you all don't have enough going on. You don't have enough to keep track of. You were so excited. You said, New Jersey, I need another regulation, another rule to make my life more difficult when it comes to leave administration, and they delivered. Let's go to the next slide. So, effective on July 17th of this year, there's going to be significant expansion of who is covered by the NJFLA and who is entitled to reinstatement rights. So when we think about this, it's not just an amendment to the NJFLA, but it's also an amendment to the TDI and FLI rules as well. And so when we're thinking about leaves and benefits and who's entitled to what time off and returning to work, job protected leave, we want to have an inclusive view of how these three things fit together. So again, there's the leave under the NJFLA, and then there's benefits, either disability insurance benefits for someone's own health condition, whether it's they had an injury and they need time to recover from surgery, or they're having a baby and they have a pregnancy related disability, that is TDI. FLI, family leave insurance, when something happens to a new baby or a family member that they need to care for. Next slide, please. All right, so here is the overview, and hopefully you all have heard about this before, but we're going to recap it and then we're going to break each of these down, right? So the first big one for our smaller or medium-sized employers, NJFLA previously applied to employers with 30 or more employees. It is now 15 or more employees, regardless of location. So wherever you have employees in the country, we're going to add all of those up. And for any of those employees in New Jersey, if you have more than 15 employees total, they may be eligible for NJFLA. For the New Jersey employees who want to take time off under the NJFLA, it is now they are now going to be eligible much sooner than they were previously. Now, after 3 months of employment and 250 hours worked in the last 12 months, you may be eligible for NJFLA. If you need time off for one of the qualifying reasons, you're having a baby, you have a serious health condition, you're caring for a family member with a serious health condition, the reasons that we covered earlier. So remember, previously it was 12 months of service and 1,000 hours. It has been significantly reduced, and this is regardless of your size, if you have 15 or more employees. So this is going to impact your recent hires, right? So this is a really important revision to the statute. Job protection. This is a big one, and we're going to talk about this a lot and give you all the information that we have with a note that we think more information is to come. Employees who receive FLI or TDI benefits must be restored to their original position or an equivalent position with pay, terms and conditions of employment, just like if they were on NJFLA leave. So before July 17th, the state said, okay, if you're approved for time off, if you're taking time off and you qualify, here's the benefits that you're eligible for, but we're not guaranteeing any job protection. Now, if you are receiving benefits, according to the way the statute is written and without further guidance, you have a right to reinstatement. And why that is so significant, and we're going to get into this, is the length of time that you can receive benefits for is substantially longer than the 12 weeks of unpaid NJFLA leave. And as an attorney, I really hate doing math, but it does require us to get into some math here, and we're going to do that. We're going to break down what that means. The other big ticket item, and again, we're going to touch on all of these in more detail. Employees who are eligible for TDI or FLI and sick time, so New Jersey paid sick leave, the employee has the right to choose what order they want to take their benefits, and only one type of benefit can apply at a time. So what that means is we cannot say to employees, you must use sick time before you go out and take the state benefits. We cannot say you must go get your disability first, then take your sick time. The employee chooses. The other piece of that is you cannot supplement TDI or FLI with sick time. So some of us have had generous policies where we've said, hey, we want to help the employees be made whole while they're out. The state has said we cannot do that anymore as of July 17th. Next slide, please. All right, so we have recapped some of this in a visually friendly chart. I'm a visual person, so I love charts. And again, all these materials will be available to you. But just to really show again the juxtaposition between where we are now and where we're going, more employers are covered. Much easier for employees to be eligible for NJFLA because they only have to work for 3 months and have 250 base hours in the preceding 12 months. And there are now these significant reinstatement rights that did not exist before. So big changes. And we're going to need additional guidance. We expect there's going to be additional guidance coming in July from the Department of Labor. They said on their website, there's like a little line. I think we have the link to that coming up later where they said, oh yeah, by the way, in July, when the law goes into effect, at some point we'll give you some guidance. So isn't that fun? Isn't that fun for all of us? But we're certainly going to be on the lookout for that, and we'll circulate updates as it becomes available. Next slide, please. Okay, so we have our very first code. So for anybody who is receiving any sort of credit for this presentation, the first code is 98290. 98290. I feel like I'm calling a lottery when I say these codes, so that's really fun for me. But make a note of that because you're going to need it for your credit. Okay, next slide. Great. All right, so we've got our first typo. So this is about Bob. Bob began working for Widgets Inc. on November 1st, 2025. Widgets Inc. is a New Jersey-based employer with 10 employees working in New Jersey and 7 employees working out of state. Bob works in New Jersey. He works approximately 40 hours a week since he started, so he's full-time. And he comes to HR and he says, guess what? July 18th, I'm going to take time off to care for a family member that has a serious health condition. So we're going to put our thinking caps on back to like when we're in school and we had those fun like algebra calculations, right? But we're going to figure out, is Bob entitled to NJFLA leave at that time? Next slide. So hopefully you all thought, yes, he's going to be eligible for NJFLA leave. Why? He was hired in November 2025. He's going to be employed for less than a year. But remember, effective July 17th, he only has to have worked for 3 hours and only has to have worked 250 hours during the last 12 months, which we know that he hit because he works 40 hours a week. We know that Widgets Inc. is a covered employer because it has more than 15 employees total. There were some in-state and some out-of-state, but we look at the number of employees collectively. So even though Bob has not been with the employer for a year, because of the amount of hours that he's worked and because they're covered, as of July 17th, he's going to be eligible for NJFLA. Next slide. All right, another question. And this question relates a little bit. We had that Q&A. Someone wrote in earlier about what if I'm a PA employer and I have have an employee in New Jersey. We're going to talk about that in this hypo. In the hypo, it's a California-based company, but the same premise applies. So here we have Goblet Inc., which is a California-based company with 500 plus employees, and it's headquartered in San Francisco. It is not a New Jersey-based company. Cedric is the company's only New Jersey employee, and he works remotely. He previously worked full-time for another New Jersey-based employer. He started working for Goblet Inc. on June 1st of this year. In July, unfortunately, Cedric and his brother are in a car accident, and he says, I cannot come to work for 2 months because of my injuries. He does not have any sick days available yet. What type of leave is available to Cedric? I'll just give everyone another minute just to take that all in and then we'll break it down. Okay, next slide. All right, so Cedric is not eligible for NJFLA because he has not worked for 3 months and 250 hours, right? He started on June 1st, but he will be eligible for TDI because he needs time off for his own serious health condition. And we said in the hypo, remember, he worked for another New Jersey employer before working for Goblet Inc. And as Ruth told us earlier, the eligibility for benefits is about total amount of time worked in New Jersey and how many wages you've earned during that time, not necessarily for the same employer. Now, as written, the amended statute says that employees are entitled to reinstatement rights if they're getting TDI, even if they're not eligible for NJFLA. And this is where we expect the state to provide guidance. But as currently written, this means that until we get additional guidance, Cedric would have job protected leave for up to 26 weeks. So he only asked for 2 months. But if he's not eligible to recover, and even though he's a new hire, and even though he's not eligible for NJFLA or FMLA, the way the statute is written, he has reinstatement rights for as long as he's out and receiving TDI. So that is really significant. That is a huge expansion of job protected time away from work. Currently, you're only entitled to job protected leave for up to 12 weeks of NJFLA, which usually runs concurrently with FMLA if you have 50 or more employees, which we'll talk about. So this is really significant. Next slide.
Lisa, I just want to, part of the question too was, do we count part-timers, part-time people as counting our employees, I think is part of that on the question that came in. And I just want to make sure we address that, which is yes, we do count them. And people are eligible for NJFLA even if they're part-time, so long as they meet those eligibility requirements.
Great point. Yes. Thank you, Ruth, for reminding me. That's absolutely right. So Sometimes it's a little confusing because we know when we have things like WARN and other statutes, sometimes we're talking about full-time versus part-time. When we are thinking about New Jersey family leave, New Jersey sick time, New Jersey benefits, it applies to full-time and part-time employees. It's just about for NJFLA, have they worked enough hours and been employed for 3 months? Thank you for clarifying. Okay, the next typo. You hired Karen for a full-time position. Oh wait, we had a Q&A. I'll just answer this quickly. Oh, well, there's a question about being a public employer in New Jersey who's exempt from the TDI plan. I think we'll answer that in the
Yeah, I mean,
comments.
yeah, I think so. The as currently in this statute, I don't believe it speaks to the public-private issue, and it doesn't seem to change that right now. But again, we may expect further guidance from the state on that particular issue because it is something, it's this 26-week period. But as the statute is drafted, I do not believe it addresses this. But we can also send a follow-up to you as well.
Yeah, I agree with that. I don't, it's not that specific at this time, so I agree. We need to continue to see what guidance the state provides on that area. Great question. The changes to the NJFLA will still apply. Okay, back to the hypo. We hired Karen for a full-time position in January of this year. Before she was hired, Karen said she was in the process of adopting a child and would need leave beginning in June. You approved 12 weeks of discretionary bonding leave beginning on June 1st. Karen will be receiving FLI benefits during her leave. Your company does not provide paid bonding leave for employees until they reach their first anniversary. So in this situation, she's going to be getting just the benefits from the state, and she's going to be going out with her new child as of June 1st.
And Lisa, I'm just going to jump in because I think this is a great place to illustrate what we were talking about earlier, where while this individual may or may not be eligible for FLA, the FLI probably carried over her meeting the eligibility requirements to apply for that could be carried over from another position. So regardless of the fact that she started for working for us in January of 2026, if she had prior time and hours that counted to her being eligible for FLI, that's why there's that difference. And I think this is just a good place to point that out. And the other part of this hypo that because it keeps coming up, I think, in clients that I'm speaking to you, and I think with Mark and Lisa as well, that we approved a discretionary bonding leave, meaning we didn't have to give that leave, but we gave it. And so it's not under any particular type of statute or requirement, but she's getting the benefit under the state benefit program. So just going to lay those things out because it gets a little muddled as we're going through it. Sorry, Lisa, I just wanted to jump in there and point out some things to make sure everybody understood them.
Yeah, no, great points. Thank you. So because you've approved 12 weeks of discretionary leave because you're the generous employers that we know you are, she will still be out on leave when the new NJFLA takes effect on July 17th. How will Karen's leave be impacted by the amended NJFLA? Next slide. Okay, so we're going to need to notify Karen that the last 6 weeks of her leave will now be covered by the New Jersey Family Leave Act and will count against her total 12-week entitlement. So remember, so if she's out from June 1st, the first 6 weeks of that until July 17th, essentially, we're going to assume that evens out to a perfect 6 weeks, is going to be this discretionary bonding time. But now the new law takes effect, right? And she has 6 weeks left of her approved time that she's requested and you've approved. And now the new law has taken effect. So 6 weeks of that is going to be counted towards her NJFLA entitlement. She will then have 6 more weeks of leave left in her possible NJFLA leave bank to use for bonding leave or any other leaves that come up during the 24-month period. We need to also tell Karen that her FLI benefits, though, will not be extended because NJFLI benefits are for a maximum of 12 weeks, right? So the way that will work is she will have the NJFLI benefits available to her during the bonding period, and she will be eligible for additional unpaid leave. But if your company does not provide for paid bonding time, the only other time available is unpaid leave. So we want to be really clear in writing with Karen about what that looks like. Be clear about what time is paid or unpaid. Karen's a relatively new employee, but if she has paid sick time, then during that leave, she can choose to apply paid sick time to a portion of that leave. Remember, she has to choose between FLI and paid sick time what she is applying to which dates. She also is going to have to work with the state to be clear about which days she's seeking benefits for and which days might be paid sick time or PTO because she's not going to be able to get both concurrently. So, as we tell all of our clients, right? And this situation is no different. Documentation and putting everything in writing is so critical. I know it's hard to keep track with all the forms and federal and state and benefits versus leave, but spelling it all out in writing and going through that exercise and building those templates internally of how you're going to address these questions is so critical. Not only because in certain cases you have to document what you're doing, especially under the FMLA, as we'll talk about, but then you're just setting expectations. We're having a clear record so that Karen knows what to expect, you know what to expect. I receive questions from clients all the time where, oh, we talked to Sally 3 months ago about, her taking leave for X, Y, and Z thing. We're very accommodating. We bend over backwards for all of our employees. But Sally hasn't come back to work, and we thought she was coming back this day, and she says it's 5 weeks from now, right? And then my question is like, okay, where did you document that? Where did you tell Sally what amount of leave she had and when you expected her to return? And it's so much easier said than done, but we want to build in these systems and build in these habits so that you don't have any confusion and so that you have consistency, right? So just use this as another reminder to do maybe sort of an internal audit of your leave process, right? So when a request comes in, what forms are employees filling out or what documentation are they providing to request the leave? What paperwork are you providing to document how much leave has been approved? Is it under just the NJFLA or is it state and federal? Have you provided information about what benefits are available and where to go to the state for help? All of these steps will only make your lives easier in the long run, right?
And I
And
just
so
want
with
to
this,
just
oh, go
jump
ahead.
in on the first part of this with, contacting her and notifying her. So, I think what's going to happen when, this goes into effect on July 17th. So one of the things to be thinking about is you're going to have folks that are out. For especially for larger employers, we have folks that are out on leave all the time. And thinking critically about how we want to deal with that. So, if someone's out on a leave and all of a sudden they now are eligible for FLA while they're out, our thought process is a best practice is to provide notification that you're now entitled to this leave and we should run it because we want to run those banks. This is something that we think is going to be is prime for the state to provide guidance on when we get it on these type of issues. For those of us that have been doing this for a while, I'm sure we remember when New Jersey passed paid sick leave. And there was a whole lot of stuff in there. And once the guidance and the Q&As and the FAQs and all of those things came out, it made it a lot easier to kind of understand how the notices and the things kind of went together. So here it's, we expect that we're probably going to get more guidance on this in terms of what, we should be doing, what our real, kind of what we're obligated to be doing. But there is a best practice here component to the answer to this as well, which is when we have folks that are out on leave that all of a sudden become eligible, they're not going to know that. But we do. So it's best practice to let them know. Now, I think that the answer to that is different if somebody had already come back and they are working and now they're eligible and they could potentially take more time, that's a different question. So just understanding in our population of folks that are out on leave and how we want to make sure that we're addressing that and that we're properly running our leave banks when we can run them is something we should be thinking about now. And that's definitely one of those things that you want to start looking at as we prepare for this July 17th date and how we're going to respond to those questions.
Yeah, absolutely. And given the nature that, this is just around the corner, we're waiting for guidance from the state. And Ruth, when you said paid sick time, I had such flashbacks to it was 2018. I feel like it was one of those pivotal moments in my career because much like this, we got the statute and there were so many questions. There was so much confusion. Also during COVID, same thing, right? Having flashbacks now. But please reach out to your outside counsel when you have questions. Because we can let you know certainly if there has been guidance that's been issued, but your outside counsel is there to be a resource to you to talk through the complex situations, to talk about what the approaches might be, if there's any risks involved in what you're considering in terms of notices and approvals. And again, this is because not only has the state greatly expanded the benefits, but there's this question of under the TDI, right? So if we have reinstatement rights under TDI, that's up to 26 weeks of benefits for your own serious health condition, and then up to 12 weeks of benefits for FLI, for family leave. So that's 38 potential weeks of time away from work where employees may have reinstatement rights. They appear to have reinstatement rights that they did not have before. So it's a very significant difference and departure from where we've been prior to July 17th. And at this point, I'm going to turn it over to Mark, I believe, to talk to us about now another fun layer to all of this, which is how the NJFLA is going to interact with the FMLA.
Thank you, Lisa. So I am going to now discuss the landscape of New Jersey leave laws after the amendment, what employers really of all sizes need to watch out for and consider, specifically the impact that these amendments are going to have on the NJFLA FMLA framework for those larger employers. Next slide, please. All right, so as you can see from this chart, what we are really dealing with is the interconnection of NJFLA and FMLA getting further apart. This is really important for larger employers that are eligible for FMLA to understand because, a lot of you with your FMLA obligations, you may have been pushing NJFLA to the side as kind of like another leave that ran concurrently with FMLA more often than not. But as we can see from this slide here, that is going to be less and less the case. Not only is the gap between FMLA and NJFLA eligible employers widening, it's going 50, used to be 50 to 30, now it's 50 to 15. But for employers that are already FMLA eligible, that employee eligibility gap is now like night and day. We're moving from a difference in application of like 250 base hours. So you can see that pre-amendment difference between 12 months and 1,250 base hours for FMLA and 12 months and 1,000 base hours for the pre-amendment NJFLA. So that's about a little over 2 months of full-time work difference. So it's much less common that there was somebody in that in-between zone. But now that NJFLA eligibility is going to hit a lot faster than that FMLA eligibility. And part of this is going to be mitigated by the 2-year NJFLA limitation for returning employees. But for new employees of large companies, this is going to matter a lot. You can see just from the chart that those employees are going to hit that NJFLA eligibility a lot faster, and they're going to have a lot of time before they hit that FMLA eligibility. So we can go to the next slide. So why is this going to matter? Because as we discussed, large employers often run into the situation where FMLA and NJFLA are run concurrently. They're eligible, an employee is eligible for both NJFLA and FMLA. They take a family leave, and you run through their pool at the exact same time. But what the amended NJFLA is going to do is going to create a lot more circumstances where an employee is entitled to NJFLA and FMLA leave, that eventually FMLA leave, but that logistically won't be able to run concurrently together. So large employers are really going to have to consider that new employees will be incentivized to use that NJFLA leave before they become eligible for FMLA leave. I think you're really going to have to start thinking about that gap between the NJFLA leave eligibility and the FMLA leave eligibility is something that employees may become more and more aware of, because this is going to give them the ability to stop their leaves from being used concurrently. And they're going to have a long time to think about it. It's about 8 or 9 month period. And so we also want to consider the impact of TDI and FLI protected leave, and however that ends up looking like, under the administration and after we receive, more guidance from the state and potentially, much further down the road regulations. But we are going to want to consider whether, what the impact of TDI, FLI protected leave is going to be on an employee who would not otherwise qualify for NJFLA or FMLA. I think like the key distinctions are, what's the impact of FLI going to be for an employee who's not yet qualified for NJFLA? And what's the impact of TDI going to be on an employee that either doesn't yet qualify for FMLA or who's working for an employer that's not even FMLA eligible? So, when you're in those buckets, you kind of want to think about, this is what I'm dealing with. This is what I'm going to have to be dealing with now. Next slide, please. So we have a hypo, a question. Michelle is employed by PA Family Dentistry, located in Philadelphia, but she lives in New Jersey. PA Family Dentistry has 45 employees. Michelle works in the office Monday through Thursday, and she works about 30 hours a week. Michelle is pregnant and says that she will need leave following her due date on July 1st, 2026. Is Michelle eligible for NJFLA? I'll give you a little bit of time to think, not too much time. All right, next slide. Let's find out. No, she's not eligible for NJFLA. So Michelle primarily works in Philadelphia, and her work is controlled by an office in Philadelphia. NJFLA is not controlled by an employee's state of residence, but rather where an employee works. And Pennsylvania doesn't have a state equivalent of NJFLA, but you do want to consider the local equivalents. We've got the Philadelphia paid sick leave law. I also think there's a Pittsburgh paid sick leave law, but that might be less relevant because it's further from New Jersey, but I'll shout that one out as well. And FMLA also doesn't apply because of the number of employees. And I also want to give a shout out to the Pregnant Workers Fairness Act. So that's, that'll fall under that disability accommodation framework, but at the same time, it's something to think about as well. All right, next question, next slide, which is a question. I knew that, but you didn't. That's all right. So Debbie was hired by ABC Company in January of 2024 to work from their Princeton office. In September of 2025, Debbie needed to care for her son after his surgery and was approved for 12 weeks of NJFLA/FMLA leave. In June of 2026, Debbie lets ABC Company know she is pregnant, and her due date is September 2026. Her due date is September 2026. She told him in June, but her due date is September. Is Debbie eligible for any additional leave? We'll give you some time.
I just want to jump in real quick because we didn't put the number in here. It's assumed, but we're assuming this employer's got over 50 employees and that they're covered, that they are a covered employer under the FMLA as well. And the second part of this really is exactly what Mark just said, right? This is where we're running those leaves together. because they're to care for. I feel like I have to go back to my slides so I can make sure that we remember what I told you at the beginning, right? So you can run them concurrently because it's a family member that she's caring for, and it's covered under both statutes. It'd be different if it was just her, but that's why we're able to run those two leaves concurrently, and we're assuming that she meets the eligibility requirements and that she's working for an entity that has over 50 employees and is covered. So sorry, Mark, go ahead. I'm not stealing your thunder. You can answer the hard part now.
No, no, I appreciate it, Ruth. Thank you for pointing that out. When we wrote ABC Company, in my head, I was like, that's a big company. And I thought, well, that's enough. But it's actually pretty important to point out we meant it as a company that's both eligible for NJFLA and FMLA because what goes on in my head is not always apparent to everyone. All right, so let's move on to the answer. All right, yes, Debbie is entitled to additional leave. Now, Debbie exhausted her NJFLA leave already. She used up that 12 weeks, and she used it in a 24-month period. Remember, NJFLA is 24 months, FMLA is 12. But Debbie is entitled to up to 12 weeks of FMLA leave, assuming she worked that 1,250 hours after her return and in that past 12-month period. And because she's as I repeated, she's going out on that leave in September. So then that 12-month is going to hit once again for FMLA. And if she applies for both TDI and FLI, she may have restatement rights beyond her 12-week FMLA entitlement. So that's, like I said, for big employers, we really have to start thinking about how is TDI and FLI going to impact that FMLA entitlement for returning employees, and how is that NJFLA eligibility downsizing going to impact my benefits for newer employees?
And I just want to say, I think that this hypo, as we were drafting it, it was giving us headache because of all the numbers and counting involved. But I think the last bullet point of this answer illustrates the point that Lisa raised earlier when she was talking about the amendments, that this is not just an amendment to the New Jersey FLA. And that has been the headline. That has been, what's being covered of the time, the amount of time someone has to work, the eligibility, like only the number of employees has been reduced, but it amends TDI and FLI too. And the last bullet point in this answer really illustrates that point because for Debbie, NJFLA has nothing to do with any of this, right? She's done with that. She's not getting any more of that. So this really illustrates what we think, that you have to think critically about the TDI and the FLI as well, and the reinstatement obligations that are currently in the statute that we're waiting for further guidance on. But that's part of this equation too, because I think, typically we've kind of looked at TDI and FLI as those are benefit programs that employees have the obligation to apply for, and then we kind of deal with them on the back end and see what they are. But there are a lot more things that are going to be attached to those. And so this answer just shows you FLI's no, or F in New Jersey FLA nowhere in the picture here on this second one. And we have to really look at TDI and FLI, and the amendments clearly put those in the crosshairs as well in terms of how we address it and what we do.
All right. Thank you, Ruth.
Oh, wait, I see a question on rolling versus calendar year, which Lisa and I are both shaking our heads because we're like, oh, this does implicate rolling or calendar year, but we're not going to make it too complicated. But, this is drafted as if the FMLA restarts on the calendar year, so that her FMLA entitlement would start again as of January of 2026. So that's kind of one of the assumptions that we baked into this one.
But because of the September leave, I think it's September. I think it might work under both. Don't quote me, please. But I do think actually, well, usually, a due date in September, you might be out on leave a little earlier than that. So there may be some conflicts there. But generally speaking, for the purpose of this hypo, she would probably be eligible under both. All right. Well, next slide. So what do employers need to do? So the most important thing now is for employers to identify which category of employer they are and adjust their policies accordingly. Employers with 15 or more employees and at least one employee working in New Jersey should update their handbooks or their New Jersey supplements to include an NJFLA policy because you're going to be providing that for a New Jersey employee now. Any employer with a TDI FLI policy is going to have to take a look at it. A popular line in those policies that we used to include was TDI or FLI is a government benefits program. It is not job protected leave. Well, now it is. So those those statements and those kind of assertions are going to have to go. More practically, you as an employer are going to want to start incorporating TDI and FLI benefits into your leave tracking practices because it's no longer enough now to maybe let the employee figure out the TDI FLI part on their own, because this is something you need to stay on top of to make sure you're not running afoul of any job protected leaves. And the exhaustion of paid sick leave. So you were never really allowed to require exhaustion of paid sick leave, but a lot of employers do it. And they used to get away with it, and it was kind of fine because employees wanted their full paychecks, right? And they had no better options. But now that the law says that TDI and FLI confers job protection and you can't even supplement them with paid sick leave, let alone replace them, employees, I think, are going to become a lot more wary of those policies that kind of stop them from saving their paid sick leave until after their TDI periods run out. And so that might be a sore point for them that they might be willing to push back on a little bit more. So something to think about. Next slide.
Thanks, Mark. Just going to jump in here just to recap that we have these outstanding questions, right? So again, the state says it's going to provide additional resources at some point in July 2026. So we're going to stay tuned for that. But we really need to understand if there's any, interpret how the state is going to interpret this new language in terms of providing FAQs and guidance about these reinstatement rights for TDI and FLI. The statute does talk about a quote unquote covered employee. Are they going to clarify what is meant by that? Or is this really a sort of indirect expansion of protected leave where we are going to be looking at 38 weeks potentially for employees who need leave both for their own serious health condition and leave to care for a family member with a serious health condition or who have a baby. And if that's the case, it begs the question, why do we have the 250 hours, 3 months criteria? I suppose that could be for someone maybe who exhausts their benefits otherwise. So there's a lot of intricacies here. There's a lot to consider. Next slide, please.
And Lisa, could you just talk a little bit more? Because I want to make sure folks understand that the issue with covered employee not being defined in the statute, and kind of where that interplay is and why that's a question.
Yeah, so in the statute as amended, it says that a covered employee shall be entitled to be reinstated to their same position or an equivalent position with same terms, conditions, and benefits if they've received TDI or FLI benefits from the state, right? But it doesn't very clearly define in the amendment who a covered employee is, and it cites to a number of different other, the TDI and FLI statutes and the original NJFLA, but that point, to my mind, needs further clarification. And so it is possible that we will see through FAQs or other guidelines, if there's another way to interpret that so that this is not the massive expansion of job protected leave that it appears to be at this point, but only time will tell. And so what we're thinking at this point is that, employers, while we await this additional guidance, obviously need to make sure that their policies are updated based on the size of your company. Certainly update the eligibility criteria for NJFLA, but err on the side of caution, right? This is a gray area. We don't think that the state is going to be super vigilant about addressing technical errors at the outset of this change. But we do think that there's a possibility for the state being vigilant about potential retaliation claims, right? So we want to be really careful about employees who seek leave and then claim that they are treated differently or that a benefit was taken away or that something negative, an adverse action happened to them about requesting leave. We want to be careful about providing guidance based on the NJFLA as it stands now, as opposed to the amendments. And I think employers would be wise um, to say to employees, listen, based on the state of the law, here is our decision about your leave request. This may be revised pending additional guidance from the state or something along those lines if it's one of those tricky situations where it falls in a gray area. Only time will tell, but we are hopeful to get guidance from the state, hopefully the beginning of July before this goes into effect. But with the state of New Jersey, you never know. Ruth, I turn it back over to you.
Thanks, Lisa. And I think the last bullet point on this slide before we move to the next one is, if there's a question, consult with your outside counsel, consult with your in-house counsel, that's helping you with these things because these are complicated questions. And I'm sure as you're sitting there, I know we've been sitting here and our heads are spinning with a million different scenarios. We're like, well, what would you do here? Because it's this, and this, and it doesn't really tell us what we should do. So, these are hard questions. Consult with the folks that you go to normally to talk to them about it, to make sure you're kind of thinking through how the math works, and what you need to be providing to folks so that we're communicating effectively. We can go to the next slide because we are almost at time. So that is what we have on the amendments as of now. Stay tuned for potential updates as the guidance comes out. We'll put out a blog or things like that to keep people posted. While we have you as a captive audience, we also wanted to just let you know that we do an annual labor and employment executive series where we cover all of these hard questions as well as a bunch of others. So if you're so inclined to put on your calendar for October 22nd, it's a full day course. You can pop in and pop out for when you can. And of course, there's CLE and SHRM credit that are available. So could go to the next slide. And hopefully our pictures look on the screen like they do in our Zoom screen. So that's us. And you can go to the next slide, please.
There's a question about codes. I believe we only had one code. But if anyone in our team, if there's any other codes or questions about codes, please pop
Yep,
that
there
in
was
the
only
Q&A.
one code.
Yeah.
So and we're going to put this up here for as we close out so that you have a chance to scan it or look at the link or you'll get this as well. But on behalf of Saul Ewing, we really want to thank you all for joining us today, bearing with us as we try to count employees, months, dates, hours, weeks, and all of those good things to make sure that we're complying with the changes that are coming down the pike here. And a reminder that a follow-up email with today's materials will be sent in the next few days, so keep a lookout for that. And I think we got to most of the questions, but if there are any that we didn't to, we'll definitely be reaching out to you. In the meantime, don't hesitate to reach out to us if you have any questions or to the folks that you normally reach out to talk about these kind of complex issues and figuring out how to handle them. We hope you enjoy the rest of your day and might join us for another webinar in the future. Thank you, everybody.